Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to head back out to Illinois, but really what we're going to be doing is heading to Washington, D.C., because we know there is not one, not two, but three petitions for certiorari, all challenging Illinois' assault weapon ban before the United States Supreme Court. We did this video yesterday, talked all about all three of those petitions. We focused a little bit on the Beavis v. Naperville case because I said, hey, there was a lot of good trolling going on there, a little bit of gaslighting. Well, I wasn't trying to suggest that they were the only memorandum. We're going to go through one of the other ones today because I think this one really very well puts the challenge to the Supreme Court, which is essentially, hey, they're thumbing their nose at you. What are you going to do about this? So today, let's geek out on that brief for a while and let's talk about why it's time for the Supreme Court to put up or shut up on assault weapon bans. Okay, the case we are talking about today is Barnett v. Raoul, one of the holy trinity of cases that come out of Illinois. Yesterday, all petitioning for writs of certiorari before the United States Supreme Court. Now, this case, which we already know is challenging, we already know all about it, we've all geeked out on enough, has one unique little aspect to it, which is one of the attorneys of records for the plaintiff is a gentleman named Paul D. Clement. Some of you may have heard of Paul D. Clement. He was the Solicitor General for the United States from 2005 to 2008. Some of you may know what the Solicitor General is, but essentially in the United States Attorney's Office, there is an attorney that will literally manage all of the litigation, all of the appellate work, basically helps dictate some of the Department of Justice policy through the effectiveness and implementation of litigations and or appeals. He decides what sorts of positions the government takes on certain issues, if they take any position at all. Very powerful position, also requiring a very sharp person to be in that spot. The fact that Mr. Clement is one of counsels of record for the plaintiffs on here, I think really boosts the chance of one of these cases being accepted by the United States Supreme Court. Now, as we talked about in the Beavis v. Naperville brief, there was some really good needling and gaslighting going on there, which is basically challenging the court. Like, you know, every one of these lower courts are just kind of thumbing their nose at you. They're showing you no disrespect. And so this issue aside, Supreme Court, what are you going to do about it? Okay. And this brief does it in a different way, but every bit as effectively. And I want to share with you that portions of the brief because you guys know the case law by now. You know Heller established the common use test. You know that Bruin absolutely, completely punctuated that, making for sure that that was the law of the land. We all understand the common use test. Why? Because it's simple freaking English. That's why. And so you don't really need to understand the case law. This is a pretty straightforward issue. Let's talk about some of the other challenges here, which is really trying to get the Supreme Court to just accept review of one of these cases so we can just get this over with. Now, let's remember that all of these cases come from an incredibly creative ruling and set of processes that happen in the Seventh Circuit. Plaintiffs point out the Seventh Circuit's approach not only eviscerates a fundamental right, but poses a broader risk to the rule of law. When a federal appellate court reduces a recent and emphatic Supreme Court decision to a mere speed bump in reviving pre-Bruin case law and greenlights state laws passed more in protest of than in compliance with this court's decision, it emboldens others to do them one better in the aloha spirit. Ooh, citing to Hawaii v. Wilson, a case that we covered in this video, absolutely the worst Second Amendment ruling in a very long time. Plaintiffs also point out here to the Supreme Court, this court needs to intervene before this open defiance spreads further. The court has repeatedly reminded courts and legislatures that the Second Amendment is not a second-class right. Unfortunately, the court now needs to instruct them that Bruin, a recent emphatic 6-3 decision of this court, is not second-class precedent. Oh, so true. Now they point out the legal background to this case, and again, throw a little more gas on the fire this way. Mere months after this court chastised lower courts for diminishing a fundamental right and reiterated that the Second Amendment protects the possession and use of weapons that are in common use, Illinois responded with defiance rather than compliance. Rather than revise and retrench existing restrictions to conform with Bruin's teachings, it did the opposite, enacting a sweeping ban outlawing many previously lawful arms, including some of the most common firearms in America. And we saw this reaction not only in Illinois, but in many other blue states, which is essentially, oh yeah, Supreme Court, watch this. And they went out and they passed even more restrictive laws than those that were struck down by the Bruin court. Plaintiffs point out, Illinois responded to this court's decision in Bruin with a fit of pique. Rather than taking this court's reaffirmation of the Second Amendment seriously and re-examining existing restrictions for compliance with fundamental right, Illinois swiftly criminalized possession of literally 1,000 previously lawful arms, including some of the most commonly used rifles, handguns, shotguns, and magazines in the land. HB 5471 is akin to the law responding to Gideon by stripping defendants of previously recognized rights to counsel. The lower courts should have made short work of this act of legislative defiance. And even though it may be stating the obvious, the plaintiffs do an excellent job at talking about the precedent that this sets if we allow lower courts to completely disregard the Supreme Court. This court cannot let stand the Seventh Circuit's approval of Illinois' open defiance of this court's precedents. Indeed, as antithetical as HB 5471 is to the Second Amendment, the Seventh Circuit's cavalier treatment of this court's precedent poses an even broader threat. They further point out, and this is obvious, when federal appellate courts dismiss Supreme Court tests as slippery and circular, discount Supreme Court decisions as empirically unsupported, and elevate abrogated circuit precedent over this court's instructions, other courts feel emboldened to follow suit. And of course, case in point, Hawaii v. Wilson, one of the most bold, brash, and offensive opinions ever to be put on paper. Now, for those of you who have been following this case, you will recall that the way the Seventh Circuit upheld Illinois' rather unconstitutional gun ban here is by declaring that the types of firearms and magazines that were in question were not even protected by the text of the Second Amendment. That's right, they were not protected arms. And they went based upon some language that had been in Heller about the Second Amendment not necessarily protecting machine guns. And it's the typical, let's build a gigantic mountain range out of a molehill. As the plaintiffs pointed out, though, thus in the Seventh Circuit's view, Heller's treatment of machine guns means that arms that may be prohibited are not arms at all. Voila! As the magic trick makes the Second Amendment right disappear. Nice, I like that. And then, of course, they point out that, hey, there is a totem pole, there's a pecking order of courts. And, right there at the top, it's like the legal food chain, sits the United States Supreme Court. What happens if we allow that to break down? Well, plaintiffs, again, sprinkle a little gasoline on it this way. It is not for inferior federal courts to grade this court's work, let alone reject its holdings as unworkable. That is particularly true when the criticisms have already been ventilated in dissenting opinions and pre-Bruin circuit law and rejected by a majority of this court. Nevertheless, the majority continued to insist that the Seventh Circuit's own analysis, an unabashedly rights-denying decision in which the court upheld a sweeping ban on common arms based in substantial part on its view of the benefits of the ordinance, including that the arms ban reduced perceived risk and makes the public feel safer. And so ultimately, in this really well-drafted brief, which again is full of all of these, like I say, it's a little bit of gaslighting, but it's a challenge to the United States Supreme Court. It is a challenge to whether or not the United States Supreme Court intends on upholding the rule of law, because we have seen a complete degradation of the rule of law by these lower courts and these state legislators thumbing their nose at very clear Supreme Court precedent. The plaintiffs conclude it this way. In the end, then, the Seventh Circuit did not identify any historical support for its novel reserve for military test or its effort to place common magazines and semi-automatic firearms like the AR-15 rifle on the military-only side of its line. That should come as no surprise. This court already studied the same history in exhaustive detail and concluded that Apart from a few late 19th century outlier jurisdictions, American governments simply have not broadly prohibited the public carry of commonly used firearms for personal self-defense, let alone prohibited the bare possession of arms that are typically possessed by law-abiding citizens for lawful purposes. The only thing surprising is the Seventh Circuit's refusal, once again, to take this court at its word. Left standing, the decision below will leave petitioners with no choice but to continue down this fruitless path, all to the likely end of being told by the Seventh Circuit yet again that a sweeping ban on firearms somehow escapes any Second Amendment scrutiny at all. Worse still, the decision will serve as yet another model for how to make Second Amendment challenges as costly and burdensome as possible to litigate. And again, getting back to the entire concept of our justice system and the rule of law, this threatens it in so many ways. And the threat posed by the decision below is not limited to the Second Amendment. It extends to the rule of law. Disrespect for this court's decision is contagious. If Illinois' disrespect for the Second Amendment and Bruin is not promptly enjoined, other jurisdictions will follow its lead. And candidly, there is already a bunch of jurisdictions who have hopped aboard that bandwagon. The case, once again, is Barnett v. Raoul. We'll go ahead and link it up down below so you guys can geek out on the pleadings for yourself. Kudos to the plaintiffs. Fantastic work done here. If you've got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. And then finally, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.